The UDRP, or Uniform Domain Name Dispute Resolution Policy, was designed as a less expensive and quicker alternative to litigation for trademark owners trying to fight cyber squatters on the internet. But for some types of disputes, there's another option that is even less expensive and quicker than the UDRP itself, the URS, or Uniform Rapid Suspension System. The URS is an interesting dispute policy that trademark owners might want to consider, but it's only available for a limited category of domain name disputes, and it has significant drawbacks that keep it from being as important or as popular as the UDRP. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to introduce the URS, talk about when it can be used, and compare and contrast it to the UDRP. Importantly, I'm going to explain some of the most significant limitations of the URS, specifically that it only applies to certain top-level domains, that it has a high burden of proof, that it has strict filing requirements, and perhaps most significantly, that it only allows for the temporary suspension of a disputed domain name. The URS, the Uniform Rapid Suspension System, is a domain name dispute policy that was published by ICANN, the Internet Corporation for Assigned Names and Numbers, in 2013 as part of ICANN's expansion of the domain name system. At that time, ICANN was in the midst of evaluating and approving what would ultimately result in the addition of more than 1,000 new global top-level domains, or gTLDs, to compete with the so-called legacy gTLDs, such as .com, .net, and .org. These new gTLDs, which today include everything from .AAA to .Zurich, created new opportunities for cyber squatters. So, trademark owners wanted a simple way to deal with what could become an even larger problem on the internet. The answer was the URS. Unfortunately, though, the URS turned out to be a much more complicated and severely limited domain name dispute policy than trademark owners had wanted. So, although it's important to know what the URS is and how it works, the truth of the matter is that it's usually not something that most trademark owners will want to consider. And instead, the UDRP remains the most powerful option that trademark owners usually rely on to deal with cyber squatters. In any event, like the UDRP, the URS allows a trademark owner to file a complaint against a domain name registrant with an approved service provider, seeking a remedy to stop counterfeiting, traffic diversion, phishing attacks, or any of the multiple problems that arise when someone else registers and uses a domain name that is identical or confusingly similar to someone else's trademark. And indeed, the URS is in many ways quite similar to the UDRP, starting with almost the same three-part test, which requires a trademark owner to prove that, number one, the disputed domain name is identical or confusingly similar to a trademark. Number two, the domain name registrant has no rights or legitimate interests in the domain name. And number three, the domain name was registered and is being used in bad faith. But the URS offers some important advantages over the UDRP, which is why it was created in the first place. First, the filing fees for a URS complaint are significantly less than those for the UDRP, which I discuss in another video. URS complaints can be filed at one of three ICANN-approved service providers, the most popular of which is the Forum, formerly the National Arbitration Forum in Minneapolis, which is also the second most popular provider of UDRP services. The Forum's filing fees for URS complaints start at only $375, as compared with $1,330 for a UDRP complaint. The other two URS providers are the Asian Domain Name Dispute Resolution Center and MFSD in Italy. Their URS fees start at $360 and $350 respectively. In other words, URS filing fees are about 75 or 80% less expensive than the UDRP. Second, because URS complaints have strict filing requirements, legal fees, at least in my practice, are also significantly less than for the UDRP. Third, in most cases, a URS decision can be obtained more quickly than a UDRP decision. The UDRP is already a fast dispute process, with decisions typically arriving about 2 months after filing a complaint. But the URS process is slightly shorter for a couple of reasons. For one thing, URS examiners, which are equivalent to panelists under the UDRP, are usually required to issue their decisions in only 3 business days, as compared with 14 days for the UDRP. Plus, URS proceedings don't allow for supplemental filings, amendments, or other interruptions that sometimes delay UDRP cases. Fourth, language is never an issue in URS cases because the URS specifically states that complaints must be filed in English. This is sometimes an obstacle for trademark owners under the UDRP, which allows or even may require complaints in other languages, leading to delays and additional costs if translations are necessary. Still, despite all of these advantages, the URS has a number of important drawbacks. First, as I mentioned earlier, the URS only applies to a specific category of top-level domains, which includes all of the new gTLDs approved by ICANN in recent years, as well as a few others. But most importantly, at least as of this recording, the URS does not apply to the most popular TLDs, such as .com, .net, and .org. As a result, because most cybersquatting activity occurs by far in the .com space, the URS is simply not available in most cases. Second, the URS, unlike the UDRP, typically does not apply to common law trademarks, something I've discussed in another video. So a trademark owner has to show that it has a national trademark registration, or that its rights have been validated through a court proceeding, or that its trademark is specifically protected by a statute or treaty. This requirement significantly limits the types of trademarks that can be invoked in the URS case. Third, as I also mentioned earlier, the URS, unlike the UDRP, does not allow a trademark owner to obtain the transfer of a disputed domain name. Instead, the URS only allows a winning trademark owner to have a domain name suspended for the life of the domain name's registration or for an additional year if it is willing to pay the renewal fee. As a result, the URS is not a good option for a trademark owner who wants to use a disputed domain name itself, and is usually something that most brands might only want to consider if they have an extremely limited budget, and if long-term relief is not important. Plus, after the URS suspension period expires, a disputed domain name will become available for registration by anyone else, which means it could be picked up by yet another cybersquatter. So it will be important to monitor a suspended domain name status and perhaps even pay for a third-party service that can help register it as soon as it expires, although there are never any guarantees that it will be possible to do so. Fourth, as the URS itself states, this dispute policy is only available for what are called clear cases of trademark abuse. Accordingly, the URS has a very high burden of proof, clear and convincing evidence, as opposed to the UDRP's lower bar, which is usually described as a preponderance of evidence. In other words, it's harder to prove a URS case than a UDRP case. Fifth, the URS rules include strict filing requirements, with complaints limited to only 500 words, as opposed to 5,000 words for a common UDRP complaint. This means that trademark owners have very little room to explain the facts of their dispute and argue the merits of their case. So any cases that require any meaningful explanation are simply not appropriate for the URS. Sixth, unlike the UDRP, where decisions are final, a losing domain name registrant can appeal a URS decision. As a result, the rapid process and low fees associated with the URS may turn out not to be such important advantages after all if a dispute becomes prolonged. Seventh, because URS examiners have to issue their decisions so quickly, they usually contain very little substantive discussion or explanation as to how each of the 3 parts of the URS test were evaluated and applied. This means that URS decisions are not very helpful in creating precedent for a trademark owner in future disputes. Finally, I should add that these are not all of the disadvantages of the URS, which really is a complicated policy with lots of other requirements and limitations. Perhaps as a result of all of these drawbacks, the URS has never proven to be a popular domain name dispute policy. For example, at the forum, fewer than 10% of their disputes are handled under the URS. And WIPO, the World Intellectual Property Organization and the leading provider of UDRP services, has never even accepted URS complaints because it considers the URS to really be an unworkable policy. Still, for trademark owners facing a clear-cut cybersquatting problem in one of the new top-level domains, the URS may be worth considering, especially if timing and budget are important. But as I always tell my clients, just be aware of the tremendous limitations of the URS before considering it too seriously. And remember that the UDRP is usually the better option. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in Internet law. Thank you.